So again, we have a tight time schedule, so let me, if we can, before we introduce our good doctor who will really remind us, as I said at the beginning, of what this effect is on children. This training, as I said, is, I'm really pleased, a co-sponsorship with DHHS and the Peacemaking Court. I think it would be good for me just to talk a little bit about the philosophy so that you understand why we are taking the position we're taking with removals. Peacemaking came to us as something shared by our indigenous communities in this country as their way of doing justice or their way of doing business. And many of us have heard about restorative justice, and there's a lot of discussion about that, and I'll simply say restorative justice is at one level and peacemaking is deeper and broader. The root of thinking in both of those is that when we look at our American justice system, because it begins and began with the criminal justice system, that model in our country focuses on an act. And then we say the act is of such significance that we have to have a reaction to it. And it is a crime. So it focuses on an act, it focuses on the reaction, i.e. a violation of the law, then it focuses on a proscription or punishment to deter future behavior. When we take that model, and by default we apply it to conflict that's not a crime, but is conflict between individuals, and further when we take that model in thinking to conflict within families, among families, and in communities, where the ongoing relationship after we're done will be there and needs to be there, that model can prove many times to be quite destructive. So, peacemaking and restorative justice says we understand the act or the harm, but our responsibility is to focus on understanding why that harm happened, restoring or reinforcing the relationships that can help the people affected by that harm so that they can move on. That's the resiliency. Nurturing that, and in that way provide a deterrence for future behavior. Okay? So, when we're looking at removal, and if we're focused on relationships, and we're focused on not accountability but responsibility, holding someone accountable already signifies implicitly that I am better than you. I am judging you. I am holding you accountable. When instead, focusing on our responsibility to recognize who's affected by that harm, how do we need to make that right, what's our individual responsibility within ourselves to each other, to our family, to our society, what is our responsibility as a community back to our society. When it works, it's powerful because it's how we're supposed to live. When it doesn't work, we already have a system well-funded in place to label it, to punish it, and throw it back out the door. There are times, that's why on removal, we talk about if we take that act, it must truly be that immediate harm. Because we've already further torn that child, oftentimes not even from the parent or the one who might be doing the harm, but from their greater community. We've already ripped that apart. We've done that. So we have to be very careful before we do that. And even when we do that, our goal in 80% to 85% of the cases coming is reunification. So if we're going to reunify, we focus on relationships, we focus on restoring those relationships, we focus on our collective and individual responsibilities, we focus on doing that in a respectful way. We're not competing, there are no winners or losers. And we focus it on identifying and nurturing the resiliency that is inherently within each of us. So with that, my fine support here from SCAO.
Thank you, Judge. Thank you. Very inspiring. And SCAO really commends all the efforts that have been made for peacemaking. And a lot of state court judges are watching Washtenaw and trying to figure out how can we implement it in our communities and how can we learn lessons from you as leaders. So thank you. Okay, really quick. How many minutes do I have? 5?
You do you.
Okay, I'll do me. Thank you. How, does everybody know how to bring a request for removal to the court? Honestly, yes, we're very clear. Okay, when we bring that request for removal to the court, how often do we prefer to bring that request for removal during regular business hours? Most of the time. Beautiful answer. Because my soapbox at SCAO is really, because I'm here and you have to listen to me, is really as often as possible, whenever we can, that we want both as DHHS and as the courts and the advocates, we want the protections of a hearing to support the decisions that we're making. So you as workers, if you're bringing a request for removal, what better place to have checks and balances on that huge decision that you're bringing forward than to have a hearing to support you in that decision? Does that make sense? So really having that hearing, having the advocates present, having the judge present to ask questions or the referee, really just kind of negates some of the liability concerns that we all are so nervous about when we make that ex parte determination or ex parte request for an order. When we do have to make an ex parte request for an order to remove, are we often using the JC04 SCAO petition form? Do we use that here?
Yeah.
I just wanted to clarify. Not that you have to, I'm just wondering. Okay, and so in that form, as a practical matter for both the courts and the families, Dr. K laid out the requirements for the removal law quite clearly, and there are 5 requirements, the 5-part test. And when we think about that 5-part test, really the contrary to the welfare and the reasonable efforts to prevent removal are critical. And so on that JC04, the petition form, as a worker, one of the most critical parts of that JC petition form is including some case facts or specific facts about that family and that child that's leading you to that removal, so that the court can really support you and base their findings on some of that case detail that you might know and you might think the court should know, but they don't. So I just wanted to encourage that as well. Make sense? Okay, not that you're making the findings for the court, you're just giving some case facts to support them when they make those findings, because they're critical to not infringe on parental rights. And then finally, I wanted to talk about something really quick to clarify an earlier message that was shared, which is really highlights why all of you coming together today is brilliant and should occur as often as possible, because the way the various branches of government hear messages or interpret the law or apply policy are based on our own perceptions and our own roles. And so there was one item that was highlighted that I thought is a great way to illustrate why coming together and talking through these issues makes us better at what we do. So one of those issues was that the child protection law was recently amended, and it has to do with one of the points we talked about bringing petitions, mandated policies, and bringing petitions to the court when there's been some type of prior termination that family has been involved with the child protection system, right? So we do have a lot of families that have prior involuntary 'That's just a symptom of, the cycle of child welfare that these kids were once in child welfare themselves, in foster care, and so on and so forth. And so when we're looking at those prior involuntary terminations, what our Michigan Supreme Court said is that it's unconstitutional to base a removal on those prior involuntary terminations alone, right? And so what do we have to do as a system? We can take the prior involuntary termination into consideration. We can take it into consideration, but only if the parent has failed to rectify the conditions that led to the prior involuntary termination. So what were the circumstances 20 years ago that led to that prior involuntary termination, and how have they failed to rectify those conditions? It's not that there's a current risk of harm to the child and they failed to rectify those conditions that are currently risking harm to that kid. It's how have the circumstances not changed since our previous involvement with them. It was just a small technical clarification that I wanted to make sure we were clear on. Does that make sense? Okay.
What's the site for that case?
Oh, Dr. K, the beautiful case. It's in Regatch.
Yeah, the case
I
is
just
Gatch,
have-
but it's in the statute now.
Yes,
So
MCL
look at-
722.638. Dr. K, thank you for your note card.
Can you repeat that?
MCL 722.638. And I can also email it out and provide the case law that was, I think, 2016. But you know, a lot of other states don't even have this prior involuntary termination language. And our state was like, oh, when did that get added? And why are we using it the way that we're using it? So it's really something to think about and highlight today. Any other questions about bringing a request of removal to the court? Any process issues or protocol issues that we want to work on? No? Okay. Thank you.